Before we begin, a quick and important disclaimer. The following content is for educational and entertainment purposes only and does not constitute legal, financial, or professional advice. Divorce law, including the specific nuances of statutes often categorized under 661 related civil codes or similar academic classifications, varies significantly by state jurisdiction and is subject to frequent legislative updates. The data and case studies presented reflect historical trends and potential outcomes based on academic research and are not a substitute for the counsel of a licensed attorney or a qualified financial planner. Viewers are strongly encouraged to conduct their own due diligence and consult with a professional regarding their specific circumstances before making any legal or financial decisions. Every single year in the United States, nearly 700,000 marriages dissolve, but there is a specific, high-stakes phenomenon emerging in academic and legal circles that most people are completely unprepared for. It is a shift so profound that it is rewriting the socioeconomic map of the American middle class. We are seeing a massive divergence where the legal mechanisms designed to provide an equitable exit from marriage are instead creating a permanent underclass of divorced individuals, particularly among those who fall into specific demographic and age brackets. While you have been told that divorce is a 50-50 coin flip, the reality is far more calculated and, for many, far more devastating. If you are currently married, considering a split, or even just interested in the stability of the American family unit, you are standing on a fault line. The old rules of no fault are evolving into something much more complex. A system where your education level, the timing of your filing, and even your zip code can determine whether you emerge with your lifestyle intact or lose 45% of your standard of living overnight. This deep dive solves a critical problem for the American audience: the information gap between television drama and the cold, hard reality of the family court system in 2026. Today we are breaking down the 661 Discourse, the academic study of the intersection between civil procedure, property division, and the long-term biological and economic outcomes for children and spouses. By the end of this masterclass, you will understand the historical trends that led us here, the case studies that reveal the true cost of litigation, and the specific data points that define who wins and who loses in the modern American divorce. To understand where we are going, we must first look at the massive shift in how the law views the contract of marriage. Historically, divorce was an adversarial process. You couldn't just leave, you had to prove a fault: adultery, abandonment, or extreme cruelty. This created a high bar for entry into the legal system. However, the divorce revolution of the 1960s and 70s, spearheaded by California's move toward no-fault statutes, changed the game. But here is the part that isn't talked about in standard legal brochures. That shift didn't just make divorce easier. It fundamentally changed the economic leverage within the household. In 2026, we see the echoes of these changes in the refined divorce rate, which currently sits at approximately 14.2 per 1,000 married women. While that number is a slight decline from the highs of the late 20th century, the complexity of the cases has skyrocketed. In high-stakes academic discourse, we look at what is known as gray divorce, the doubling of divorce rates among those over the age of 50 since the 1990s. For this demographic, the 661 context refers to the intricate web of retirement assets, healthcare proxies, and long-term spousal support that family courts must untangle. Let's look at a case study involving property division. Modern courts generally follow one of two paths: equitable distribution or community property. In the 41 states that follow equitable distribution, equitable does not mean equal. It means fair as determined by a judge. This is where the discourse becomes vital. A judge looks at a massive list of variables: the duration of the marriage, the age and health of each party, their future earning capacity, and their contribution as a homemaker. If you have spent 20 years building a career while your spouse managed the household, the potential outcomes are not a simple split. The court may award a significantly larger portion of the marital estate to the spouse with lower earning capacity to ensure they don't become a ward of the state. Furthermore, the data regarding the divorce hangover is staggering. Academic research from the Census Bureau and various university sociology departments suggests that the socioeconomic impact of divorce is not a one-time event, but a generational shift. For example, children who experience parental divorce in early childhood, ages 0 to 5, face a 45% increase in mortality risk by age 25 and a 13% reduction in their own future income. This isn't just about unhappy parents, it's about the 661 effect. the disruption of the domestic environment, and the fragmentation of capital. We also have to discuss the identity crisis in male-centered divorce discourse. Studies show that while women often face a more immediate and sharp decline in their standard of living, sometimes as much as 45% for those over 50, men often experience a total collapse of their social and professional identity. In many American households, the man's identity is intrinsically tied to his role as a provider and a father. When the legal system intervenes and shifts his status to a non-resident parent, the psychological and economic fallout is profound. Men who divorce often see a significant portion of their income redirected toward alimony and child support, requiring a total recalibration of their lifestyle. Now, why does this matter to you right now? Because the 661 discourse isn't just for lawyers. It's a blueprint for understanding the risks inherent in the modern American social contract. If you are in the sweet spot for marriage, statistically defined as ages 28 to 32, your risk of divorce is at its lowest, around 25% within the first decade. But if you marry before 18, that risk jumps to 48%. These aren't just numbers. They are predictors of your future financial and emotional stability. We are also seeing a rise in conversion divorce, where a legal separation is transformed into a full dissolution after a set period. This is often used as a cooling-off strategy, but the academic data suggests it often just delays the inevitable financial shock. In states like Nevada or Mississippi, where divorce rates remain among the highest in the country, hovering near 19 per 1,000, the speed of these proceedings can lead to seller's remorse in the legal sense, where parties realize too late that they have signed away rights to complex assets like pension plans or intellectual property. In this deep dive, we are going to peel back the layers of the family court system. We will examine the adversarial versus mediation models, and why the choice you make in the first 30 days of a split can cost you between $7,000 and $50,000. We will look at how the no-fault era has created a soulmate model of marriage that prioritizes individual happiness over institutional stability, and the massive hidden costs that this shift has placed on the American taxpayer and the next generation. This is part 1 of our 10-part series. We are moving beyond the surface-level advice of hire a good lawyer and into the granular, data-driven reality of what it means to untie the knot in 2026. Prepare yourself, because the discourse on Divorce 661 is about to get much more intense as we look at the specific legal triggers that can make or break your financial future. To truly understand the academic discourse surrounding the 661 framework, we have to look at the silent engine of the American legal system, the discovery phase. In 2026, discovery is no longer just about exchanging paper tax returns and bank statements. We have entered the era of forensic digital auditing. Imagine a scenario involving a couple in Austin, Texas. Let's call them Michael and Sarah. Michael is a senior software architect, and Sarah is a successful freelance consultant. After 15 years of marriage, they decide to file for dissolution. Under the modern 661 analytical lens, the court isn't just looking at their joint checking account. They are looking at the metadata of their lives. Digital forensic discovery in 2026 involves the tracking of shadow assets. Historical trends show that nearly 30% of high-net-worth divorces involve some level of attempted asset concealment. In Michael and Sarah's case, the discourse shifts to the valuation of non-tangible property. Michael may have stock options that haven't vested, or perhaps a side project in development that uses proprietary code. Under 661 logic, the court must determine if that intellectual property was created using marital time or resources. If Michael worked on that code at 10 p.m. on a Tuesday while Sarah managed the household, that code is often classified as a marital asset. The complexity here is staggering. How do you put a dollar value on a piece of software that hasn't been monetized yet? The court relies on expert testimony from valuation specialists who use historical trends of similar startups to project potential outcomes. This isn't a guess. It is a high-stakes calculation that can swing the final settlement by hundreds of thousands of dollars. Now, let's pivot to the concept of the marital standard of living, which is a cornerstone of the 661 discourse. In many states, the law mandates that the lower-earning spouse should be able to maintain a lifestyle as close as possible to the one enjoyed during the marriage. Imagine if a couple spends $5,000 a month on private school, $2,000 on club memberships, and $3,000 on international travel. When they split, that $10,000 monthly burn rate doesn't just disappear. It becomes the benchmark for alimony or spousal support calculations. Case studies from 2025 and 2026 suggest that courts are becoming increasingly granular. They aren't just looking at the total spent, they are looking at the recurring nature of the expenses. If Sarah can prove that the family took a luxury vacation every December for 10 years, the court may factor that expectation into her support award. This creates a massive financial burden on the higher earner, who must now support two households on an income that barely supported one at that level of luxury. This leads us to the critical distinction between separate and community property. In the 661 framework, the concept of commingling is where most people lose their financial footing. Let's look at another scenario. Imagine if Sarah entered the marriage with a $100,000 inheritance sitting in a private brokerage account. For 5 years, she never touches it. It remains separate property. But in year 6, the couple decides to renovate their kitchen. Sarah moves $20,000 from that inheritance into their joint checking account to pay the contractor. In many jurisdictions, that single transaction can be seen as commingling. By mixing those funds with marital money, Sarah may have accidentally converted the remaining $80,000 into a marital asset. The academic discourse here focuses on the transmutation of property, the legal alchemy where mine becomes ours. Step by step, the court tracks the flow of every dollar. If you cannot produce a clean paper trail, the historical trend is for the court to default to the assumption that the asset is marital. Furthermore, we must address the 2026 reality of the silver tsunami in divorce. Academic data indicates that older Americans are the fastest growing group of filers. For this group, the discourse isn't about child custody. It is about the Qualified Domestic Relations Order, or QDRO. This is a specialized legal instrument used to divide retirement benefits. If Michael has a 401k worth $1.2 million, a QDRO is the only way to give Sarah her portion without triggering massive early withdrawal penalties and tax hits. However, the drafting of a QDRO is an academic exercise in precision. If a single clause is phrased incorrectly regarding cost of living adjustments or survivor benefits, one party could lose out on decades of passive income. Case studies show that poorly drafted QDROs are one of the leading causes of legal malpractice claims in the family law sector. Beyond the finances, the 661 discourse explores the sociological impact of the 2026 legal climate. We are seeing the rise of the specialized parenting coordinator. In high-conflict cases, the court no longer leaves the parents to figure out the schedule. Instead, they appoint a third-party professional, often a psychologist or a senior social worker, who has the legal authority to make binding decisions on the fly. If Michael wants to take the kids to a baseball game during Sarah's weekend, and they can't agree, the parenting coordinator decides. This adds another layer of cost and another layer of state intervention into the private lives of American families. The step-by-step escalation from mediation to a parenting coordinator to a full-blown custody evaluation is a path that many families find themselves on before they even realize the cost. The data also reveals a fascinating trend in 2026: the impact of social media and digital breadcrumbs on character assessments in court. 61. Even in no-fault states, a spouse's behavior can influence property division if that behavior led to the dissipation of marital assets. Imagine if Michael spent $50,000 of marital funds on expensive gifts or travel for a third party during an affair. The court doesn't care about the emotional betrayal, but they care deeply about the $50,000. Sarah's legal team would use forensic accounting to track those expenditures and ask for a credit in the final distribution. In the academic world, this is known as economic misconduct. Every digital receipt, every GPS tag on a photo, and every Venmo transaction becomes a piece of evidence in the discourse of financial equity. What we are witnessing is the professionalization of the end of a relationship. It is no longer a personal matter. It is a complex, data-driven negotiation where the stakes are your future stability. But as we look at the division of bank accounts and houses, there is one factor that often outweighs them all, and it is the one thing you cannot simply earn more of later. It is the hidden tax of the legal process itself, the erosion of time and the psychological toll of prolonged litigation. As we prepare to move into the next phase of this masterclass, we have to ask, what happens when the court looks past the bank accounts and starts looking at your future potential? What happens when the law decides that your career itself is a marital asset that must be appraised and divided? The answer lies in the controversial world of professional degree valuations and the concept of enhanced earning capacity. This is where the 661 discourse moves from what you have to who you are. In the next part, we are going to look at the explosive battle over professional licenses and degrees. If you worked while your spouse went to medical school, do you own a piece of their future surgeries? The answer in 2026 might shock you, and the specific case studies we will examine will change how you view the concept of a career forever. We will also dive into the secret world of vocational evaluations, where a court-appointed expert determines exactly how much money you should be making, even if you are currently unemployed. The trap is being set, and in Part 3 we will show you how to see it coming. The academic discourse on the 661 framework now brings us to one of the most contentious battlegrounds in the modern American legal system: the valuation of human capital. In 2026, the court is no longer satisfied with looking at what you have in your bank account today. It is obsessively focused on what you are capable of earning tomorrow. This is where the concept of enhanced earning capacity and vocational evaluations becomes a reality for thousands of couples. Imagine a scenario involving David and Jennifer. They live in Charlotte, North Carolina. David spent the last 8 years working as a marketing executive, while Jennifer attended medical school and completed a high-stakes residency in neurosurgery. Just as Jennifer starts her first year as an attending physician with a massive salary jump, the marriage dissolves. Under the 661 lens, David's legal team isn't just looking for a share of their modest savings. They are arguing that Jennifer's medical license is a marital asset. This is based on the theory that David's financial and emotional support was the fuel that allowed Jennifer to acquire a high-value professional credential. In the academic discourse of family law, this is often referred to as the reimbursement alimony or professional degree valuation model. Historical trends in states like New York have historically treated these licenses as marital property, though the national trend in 2026 is shifting toward a more complex reimbursement or lifestyle maintenance model. Step by step, the court-appointed valuation expert will look at Jennifer's projected lifetime earnings as a neurosurgeon compared to what she would have earned with only a standard undergraduate degree. The delta, the massive difference in those two numbers, is then capitalized into a present-day dollar value. Imagine if the expert determines that Jennifer's degree is worth a net present value of $2.4 million. Even though that money hasn't been earned yet, the court might award David a significant distributive award, or a higher percentage of other marital assets to compensate for his contribution to that future wealth. This creates a scenario where Jennifer is effectively paying a mortgage on her own career for the next decade. But what happens if the situation is reversed? This brings us to the controversial world of vocational evaluations. Imagine if David, after being laid off from his marketing job, decides to take a lower-paying role or perhaps even stop working to focus on a creative passion project during the divorce proceedings. In the eyes of a 661 analysis, this is often viewed as underemployment or voluntary impoverishment. The court will not simply accept David's current income of $0 or $30,000. Instead, they will hire a vocational expert, a professional trained to analyze the labor market in 2026. This expert will sit down with David for a battery of tests and an interview. They will look at his resume, his past earnings history, and the current demand for marketing executives in the Charlotte metropolitan area. They will then produce a report stating that David has an earning capacity of $150,000. The court then imputes this income to him. This means that when the judge calculates child support or alimony, they act as if David is actually making that six-figure salary. If the potential outcomes of this imputation are not managed, David could find himself owing support payments that exceed the actual cash he has on hand. The academic logic here is to prevent spouses from intentionally tanking their careers to avoid financial obligations, but for many, it feels like being chased by a ghost income that doesn't exist in reality. We must also examine the intersection of 661 discourse and the gig economy of 2026. A significant portion of the U.S. workforce now derives income from multiple streams, freelancing, content creation, or digital platforms. For a character like Marcus in Los Angeles, who manages a portfolio of niche e-commerce sites and a YouTube channel, the valuation process is a nightmare. Historical trends show that traditional accounting methods struggle with the volatility of digital assets. The court has to determine what part of Marcus's income is a result of his ongoing work, which is separate property after the filing date, and what part is the result of the systems built during the marriage, which are marital. The step-by-step audit of Marcus's digital footprint involves looking at the conversion rates, the shelf life of his content, and the brand equity he built while married. If the marriage lasted 10 years and the channel was started in year 3, 7/10 of the brand's foundational value might be subject to distribution. Case studies from recent California filings show that courts are now hiring social media valuation experts who treat a YouTube subscriber base similarly to a traditional customer list in a brick-and-mortar business. The 661 Discourse suggests that if you built an audience while your spouse provided the stability of a health insurance plan and a home, that audience is a fruit of the marital labor. This leads to the massive complication of the double dip. This is an academic term for when an asset is counted twice in a divorce. For example, if Marcus's business is valued at $1 million and that value is divided as property, can the income from that same business also be used to calculate alimony? In many jurisdictions, the answer is no, because that would be unfair. However, in the 2026 legal climate, the lines are blurring. Legal teams are finding ways to argue that the business has a tangible value as a saleable asset and a separate value as a recurring income stream. Navigating this requires a level of financial literacy that most people simply do not have when they enter the courtroom. Furthermore, we are seeing the rise of the lifestyle analysis expert. Unlike a standard accountant, these professionals look at the flow of money to prove that a spouse is hiding income. If Marcus claims he only makes $60,000 a year, but his Instagram shows him flying first class and his bank statements show $40,000 in annual credit card payments, the lifestyle analysis expert will work backward. They calculate the net worth increase and the cost of the lifestyle to prove that Marcus must be making at least $200,000. In the 661 Discourse, your lifestyle is the ultimate witness against you. Imagine if the court finds that there has been a significant dissipation of assets. In 2026, this includes not just gambling or gifts to paramours, but also risky investments in high-volatility digital assets without the other spouse's consent. If Jennifer can prove that David lost $200,000 in a failed speculative venture during the final year of the marriage, the court may debit that entire amount from David's side of the ledger. The academic principle of the marital waste doctrine is being applied with renewed vigor in an era of complex financial products. The depth of this discourse reveals that divorce in the United States is no longer just a legal dissolution. It is a full-scale economic restructuring. You are not just fighting over a house, you are fighting over the very definition of your future productivity. The court is effectively betting on your success, and then asking you to pay out a portion of that bet today. But as we look at the battle over professional degrees and imputed income, we are ignoring the most volatile variable of all, the transition of the household. As we move toward the next section of this masterclass, we have to look at the physical reality of the split. What happens when the academic discourse of 661 meets the brutal reality of the 2026 American housing market? How do you divide a home that has a 3% mortgage rate when the new rates are double that? The decision to sell or stay is no longer just emotional. It is a mathematical trap that is keeping thousands of divorced couples locked in a financial stalemate. In the next part, we are going to dive into the housing crisis within the divorce process. We will look at the buyout strategies that are actually working in 2026 and the devastating mistakes people make with their equity. We will also explore the rise of nesting arrangements, where the parents move in and out while the children stay in the home, and why the academic data suggests this might be a recipe for legal and emotional disaster. The walls are closing in, and in part 4 we will show you how to find the exit. The intersection of the 661 academic framework and the 2026 American real estate market has created a phenomenon experts are calling the mortgage lock-in trap. To understand the gravity of this, imagine a couple named Robert and Elena living in Phoenix, Arizona. They purchased their family home in 2021 with a fixed interest rate of 2.75%. Their monthly mortgage payment is $2,200. In the current 2026 climate, if they were to sell that home and each buy a smaller individual property, they would likely face interest rates hovering between 6.5 and 7.5%. Even a modest townhouse would cost them $3,500 a month. This discrepancy creates a massive hurdle in the equitable distribution of assets because the house is no longer just a physical structure. It is a low-interest debt vehicle that has immense value in itself. Under a standard 661 analysis, the court looks at the net equity of the home. If the house is worth $800,000 and they owe $400,000, there is $400,000 in marital equity to divide. Step by step, the traditional path involves one spouse buying out the other. If Elena wants to keep the house, she must pay Robert $200,000. However, the 2026 reality is that Elena likely cannot qualify to refinance the $400,000 loan in her own name at current rates while also taking out an additional $200,000 to pay Robert. The math simply fails. Case studies from this year show that this often forces a sale of the asset, effectively destroying the low-interest benefit and leaving both parties with significantly less purchasing power than they had as a unit. The discourse has shifted toward creative legal solutions, such as the deferred sale of the family residence. In this scenario, Robert and Elena might agree, or be ordered by a judge, to remain as co-owners of the property for a set period, perhaps until their youngest child graduates high school. Elena lives in the house, and Robert receives a credit for his share of the equity later. This is often referred to in academic circles as a Duke order. The potential outcomes of this strategy are double-edged. While it provides stability for the children, it ties Robert's credit and capital to his ex-spouse for years, preventing him from moving on financially or purchasing a new home of his own. Now consider the rise of the nesting arrangement, an experimental sociological trend that has gained traction in high-cost urban centers like Seattle and New York. Imagine if Robert and Elena decide that instead of moving the children back and forth between two apartments, the children stay in the family home and the parents rotate in and out. When it is Robert's week, Elena stays in a small studio apartment elsewhere. When the week ends, they swap. Historical trends suggest that while this sounds altruistic and child-centric, it often results in a legal and emotional pressure cooker. The 661 discourse highlights the lack of clear boundaries. If the water heater breaks during Elena's week, but she cannot afford the repair, is Robert responsible for half of a house he only lives in 50% of the time? The academic data indicates that nesting rarely lasts more than 6 to 9 months before the lack of privacy and the logistical nightmare of maintaining 3 residences leads to a total collapse of the agreement. We also have to analyze the impact of the capital gains tax in a 2026 divorce. Under Section 121 of the Internal Revenue Code, a married couple filing jointly can exclude up to $500,000 of gain from the sale of their primary residence. If they divorce before the sale, that exclusion drops to $250,000 each. In high appreciation markets, this $250,000 difference is a massive tax hit that many couples fail to factor into their settlement negotiations. An academic deep dive into 661 reveals that the timing of the final decree of divorce can literally cost a couple $50,000 to $100,000 in unnecessary taxes. Professionals now use a step-by-step tax liability projection to determine if a sale should happen before or after the legal status of the marriage changes. Beyond the primary residence, the discourse extends to the valuation of vacation properties and short-term rental portfolios. Imagine if Robert and Elena own 2 Airbnb properties in Sedona. In 2026, these are not just real estate, they are operating businesses. The court must decide if the value is based on the brick-and-mortar appraisal or the capitalized income stream. If the properties generate $5,000 a month in net profit, that income is factored into the spousal support calculations. However, if Robert is the one managing the bookings and cleaning crews, he may argue for a management fee that reduces the marital pot. This is where forensic accounting becomes essential. The court examines the historical trends of occupancy rates and maintenance costs to ensure that one spouse isn't inflating expenses to hide the true value of the asset. Furthermore, we are seeing the emergence of the mortgage assumption strategy as a primary goal in 661 litigation. While most modern mortgages have a due-on-sale clause that prevents a simple transfer of the loan, some FHA and VA loans are legally assumable. In 2026, a veteran spouse who can offer an assumable 3% mortgage to their ex-partner as part of the settlement has a powerful bargaining chip. This can be used to trade off against retirement accounts or other liquid assets. The discourse focuses on the intrinsic value of the interest rate itself, which can be quantified by calculating the total interest saved over the remaining life of the loan. But what happens when the house is underwater, or the equity is negligible? In certain regions where the 2026 market has seen a correction, couples are facing the prospect of a short sale or a deed in lieu of foreclosure in the middle of their divorce. The academic principle of debt distribution becomes paramount here. If the house is worth less than the debt, who carries the deficiency? The 661 framework suggests that debt incurred for a marital benefit, like the family home, is a joint responsibility. However, if one spouse can prove the other was responsible for financial mismanagement that led to the equity erosion, the court may shift the burden. The complexity of housing and divorce is a microcosm of the entire 661 struggle. It is a battle between the need for immediate liquidity and the long-term necessity of shelter and stability. As families navigate the high-interest, high-cost landscape of 2026, the house often becomes a cage rather than an asset. It binds people together long after the emotional connection has vanished, creating a state of legal limbo that can last for years. As we conclude this examination of the physical assets, we have to look at the even more complex world of intangible security. What happens to the health insurance, the life insurance policies, and the Social Security benefits that were predicated on a lifelong union? The 661 discourse is about to move into the realm of the safety net. In the next part, we are going to explore the high-stakes world of insurance and federal benefits. We will look at the 10-year rule for Social Security and why some couples are waiting exactly 3,651 days to file their final papers. We will also dive into the COBRA trap and the hidden costs of losing a spouse's employer-sponsored health care in an era of rising medical premiums. The financial math of staying alive and healthy is about to take center stage, and in Part 5 we will show you the data that most people miss until it is far too late. The academic discourse surrounding the 661 framework must now pivot to the invisible threads of the American social safety net, specifically focusing on the intersection of healthcare and federal entitlements. In 2026, the cost of individual healthcare in the United States has reached a critical threshold, making the loss of a spouse's employer-sponsored insurance a primary economic driver in divorce negotiations. Imagine a scenario involving a couple named Thomas and Linda living in Columbus, Ohio. Thomas has worked for a major logistics firm for 22 years, and his family plan covers Linda and their 2 college-age children with a low deductible and extensive specialist coverage. Linda, who has spent the last decade managing a small boutique and operating as a self-employed consultant, relies entirely on this coverage. When the 661 analysis is applied to their dissolution, healthcare is not just a line item, it is a massive future liability. Under the Consolidated Omnibus Budget Reconciliation Act, or COBRA, Linda has the right to continue her coverage under Thomas's employer plan for up to 36 months following a divorce. However, the cost is staggering. In 2026, the average monthly premium for an individual COBRA plan can range from $800 to $1,200, because the employer is no longer subsidizing the cost. Linda must pay 102% of the full premium. Historical trends show that many spouses in Linda's position fail to realize that this is a temporary bridge, not a permanent solution. Step by step, the court must decide if Thomas should be responsible for paying these COBRA premiums as part of his spousal support obligation. If the court determines that Linda's earning capacity is insufficient to cover her own health care, Thomas may be ordered to pay for this coverage for the full 3-year period, a potential outcome that could cost him over $40,000 in post-tax income. Beyond the immediate crisis of COBRA, we must examine the 10-year rule for Social Security benefits, a cornerstone of the 661 academic debate. Under federal law, if a marriage lasts at least 10 years, a divorced spouse is entitled to claim benefits based on their ex-spouse's earnings record, provided they remain unmarried. This does not reduce the amount the primary earner receives, but it provides a critical floor for the lower earner's retirement. Imagine if Thomas and Linda have been married for 9 years and 8 months. In the 2026 legal landscape, Linda's attorney would likely move to delay the final decree by a few months. This is known as the strategic delay. By crossing the 10-year threshold, Linda gains access to potentially thousands of dollars in monthly retirement income decades down the line. Case studies from recent years show that a single day, filing on day 3,651 instead of day 3,650, can be the difference between a secure retirement and a reliance on supplemental security income. The discourse also covers the intricate world of life insurance as a security for support. In many 661 settlements, the higher-earning spouse is required to maintain a life insurance policy with the ex-spouse as the beneficiary. This ensures that if Thomas were to pass away, the child support or alimony payments Linda relies on would be replaced by a death benefit. However, the academic challenge in 2026 is the insurability of the payer. If Thomas has developed a health condition during the marriage, the cost of maintaining a new term life policy might be prohibitive. The court then has to decide if an existing whole life policy with cash value should be divided as a marital asset or held as security. Step by step, the legal teams must audit the policy's ownership, the beneficiary designations, and the premium payment history to prevent a lapse that would leave the lower earner vulnerable. We also have to discuss the impact of divorce on the 2026 tax landscape, specifically regarding the dependency exemptions and the head of household filing status. With the current tax codes, the right to claim children as dependents is a valuable asset. In the 661 framework, this is often traded like currency. Thomas might agree to pay a slightly higher monthly support amount in exchange for the right to claim the children on his taxes every year, which could provide him with a significant annual refund. The discourse highlights that without a specific, written agreement in the divorce decree that overrides the standard IRS residency rules, the parent with whom the child lives for the majority of the year generally gets the exemption. Historical trends suggest that failure to clarify this in the 661 filing leads to thousands of audits every year as both parents attempt to claim the same child. Now, consider the role of the Qualified Medical Child Support Order, or QMCSO. This is a specialized legal document, similar to a QDRO, that ensures children remain covered under a parent's group health plan, regardless of which parent has physical custody. In 2026, with the rising costs of pediatric care and mental health services, the QMCSO is a vital part of the 661 deep dive. It prevents a parent from simply dropping the children from their plan during an open enrollment period to save money. The discourse emphasizes that these orders must be drafted with extreme precision to be accepted by the employer's plan administrator. One wrong word regarding the definition of a dependent or the scope of covered services can render the order useless, leaving the children uninsured during a medical crisis. Furthermore, we must address the concept of the survival benefit in pension plans. For many American workers in the public sector or older industrial firms, the pension is the largest asset after the home. In the 661 discourse, the court must decide if a former spouse is entitled to the joint and survivor annuity. This means that if Thomas dies after retirement, Linda continues to receive a portion of his pension for the rest of her life. Historical trends show that if this is not specifically addressed at the time of divorce, the right is often lost forever. In 2026, valuation experts are using sophisticated actuarial tables to determine the present value of that survivor benefit, which can often be worth hundreds of thousands of dollars depending on the ages of the parties. Imagine if the discourse shifts to the impact of divorce on disability benefits. If a spouse becomes disabled during the marriage, the 661 analysis must determine how Social Security disability insurance or private long-term disability payments are treated. Are they a replacement for future earnings, which might be separate property, or are they a marital asset because the premiums were paid with marital funds? The potential outcomes vary wildly by state, but the trend in 2026 is toward treating disability payments as income for the purposes of support calculations, but not as an asset to be divided. This creates a precarious situation for the disabled spouse, who may see a significant portion of their limited income redirected to an ex-partner. What we see in this section of the masterclass is that the 661 framework is a complex web of federal and state regulations that extend far beyond the family court. It is a system where a mistake in a tax filing or a missed deadline for a COBRA application can have a compounding negative effect that lasts for decades. The academic discourse proves that you cannot view your assets in a vacuum. They are all connected to the larger infrastructure of the American economy. As we conclude this deep dive into the safety net, we have to face the most emotional and high-stakes portion of the entire process. We have talked about the money, the houses, and the insurance, but we haven't talked about the people that the system is supposedly designed to protect the most. The 661 discourse is about to enter the territory of the best interests of the child. In the next part, we are going to break down the science of custody evaluations. We will look at how the court determines who is a fit parent in 2026, the rise of the 50-50 default across the United States, and the controversial role of the guardian ad litem. We will also explore the data on relocation. What happens when one parent wants to move across the country for a new job? The battle for time is about to begin, and in Part 6, we will show you how the clock becomes the most expensive asset of all. The academic discourse now moves into the most sensitive and high-stakes territory of the 661 framework, the allocation of parental responsibility and the quantification of time. In 2026, the United States has seen a seismic shift in how courts view the parent-child relationship. The era of the primary custodian and the weekend parent is rapidly fading, replaced by a sophisticated, data-driven approach to shared parenting. Imagine a scenario involving a couple in Denver, Colorado. Let's call them James and Sophia. They have 2 children, ages 7 and 10. James is a civil engineer who has historically worked long hours, while Sophia is a part-time librarian who has managed the majority of the day-to-day school runs and extracurricular activities. Under the 661 lens, the court does not simply look at who has been the primary caregiver in the past. Instead, the academic discourse focuses on the maximum involvement principle. In 2026, over 35 states have adopted legislative language that presumes 50-50 shared physical custody is in the best interest of the child unless there is clear and convincing evidence to the contrary. This is a massive departure from historical trends where mothers were awarded sole physical custody in nearly 80% of cases. For James and Sophia, this means the court starts with the assumption that the children will spend exactly 182.5 days with each parent. To untangle this, the court often employs a guardian ad litem or a custody evaluator. This is a forensic process that involves a step-by-step audit of the family's life. Imagine if a court-appointed evaluator spends 20 hours interviewing James, Sophia, the children, their teachers, and even their pediatricians. They are looking for parental fitness, which in the 2026 discourse is defined by co-parenting capacity. The court is less interested in who makes the best pancakes and more interested in who is more likely to encourage a positive relationship with the other parent. If Sophia attempts to limit James's time by citing his busy work schedule, the court may view this as restrictive gatekeeping, which can actually result in Sophia losing time. The academic data suggests that high-conflict parents who cannot communicate effectively are increasingly being ordered into parallel parenting arrangements, where contact is minimized and all communication is funneled through court-monitored digital platforms. The discourse also introduces the right of first refusal. This is a common 661 clause that states if one parent is unavailable for a set period, usually 4 to 8 hours, during their scheduled time, they must offer the other parent the opportunity to care for the child before calling a babysitter. Imagine if James has a late-night project. Under this rule, he must call Sophia. While this sounds logical, case studies in 2026 show it often becomes a tool for harassment or micromanagement of time. The step-by-step litigation over what constitutes a work emergency versus a social engagement can rack up thousands of dollars in legal fees, making the clock the most expensive asset on the balance sheet. We must also address the relocation trap. Imagine if Sophia receives a life-changing career opportunity in Atlanta, Georgia. She wants to move with the children. In the 661 framework, this is known as a removal case, and it is often referred to as the nuclear option of family law. The court applies a rigorous multi-factor test. Does the move improve the quality of life for the children? Is the motive to frustrate the other parent's visitation? Can a realistic substitute visitation schedule be created? Historical trends show that courts are becoming increasingly hostile to relocation. In 2026, the potential outcomes for Sophia are grim if James objects. The court may rule that the children must stay in Denver to maintain the 50-50 bond with their father. Sophia is then forced to choose between her career and her children, a sociological phenomenon known as the geographic bind. The discourse then turns to the financial implications of this time. Child support in 2026 is mathematically tethered to the number of overnights. In many jurisdictions, if James crosses the threshold of 146 overnights, or 40% of the year, his child support obligation drops significantly. This creates a cliff effect, where parents fight aggressively for an extra 10 or 20 nights not out of a desire for time, but to avoid a massive financial payment. The 661 academic critique argues that this monetization of children is one of the most destructive elements of the modern legal system. It turns the bedroom of a child into a bargaining chip in a high-stakes financial negotiation. Furthermore, we must look at the extraordinary expenses category. Child support typically covers basic needs: food, shelter, and clothing. But what about the 2026 reality of elite youth sports, private tutoring, and mental health therapy? Under 661 protocols, these are usually divided pro rata, based on income. If James earns 70% of the total household income, he pays 70% of the $400 a month club soccer fee. Step by step, the legal teams must define what constitutes an agreed-upon expense. If Sophia signs the 10-year-old up for a $2,000 coding camp without James's written consent, is he liable? The case studies suggest that without a hyper-specific parenting plan that defines the decision-making process for expenditures over a certain dollar amount, these families end up back in court every 6 months. The complexity deepens when we consider virtual visitation. In 2026, the discourse includes the legal right to digital access. A standard parenting plan now includes specific windows for FaceTime, gaming together on platforms, or even monitoring the child's social media activity. If James prevents the children from calling Sophia during his week, it is treated as a violation of a court order. The academic focus here is on maintaining the psychological presence of the absent parent. However, the data shows this often leads to digital intrusions, where a parent uses the video call to inspect the other parent's home or overhear private conversations. Finally, we have to look at the age-out transition. As children reach the ages of 14 or 16, the 661 framework begins to incorporate the voice of the child. While children in the U.S. generally do not get to choose which parent they live with until they are 18, many states in 2026 require judges to give substantial weight to the preferences of mature minors. Imagine if the 10-year-old in our scenario reaches 15 and decides they want to live entirely with James because his house is closer to their friends. The court must balance this preference against the long-term goal of maximum involvement with Sophia. This transition often creates a secondary wave of litigation, just as the original support orders are nearing their end. The 661 Discourse reveals that custody is no longer a status. It is a logistical and financial operation. It is a system of checks and balances that treats time as a currency and parental behavior as a performance to be graded by the state. But while we have focused on the children and the parents, there is a silent party in the 2026 divorce process that is often overlooked until the final signature is required. As we conclude this part on the battle for time, we have to look at the entity that actually makes the final decision. We are moving from the home and the school into the black box of the American courtroom. In the next part, we are going to explore the judicial discretion model. We will look at how a judge, a human being with their own biases and history, interprets the 661 data. We will dive into the world of ex parte orders, the status quo doctrine, and why your first hearing might be the most important 30 minutes of your life. The gavel is about to fall, and in part 7, we will show you how the personality of a judge can outweigh a decade of evidence. The academic discourse now enters the courtroom, moving away from the clinical world of spreadsheets and into the subjective reality of judicial discretion. In 2026, the American family court system operates under what scholars call the black box of the judiciary. This means that while the 661 framework provides a structured set of rules, the ultimate application of those rules is filtered through the specific perspective of a single human being: the judge. Imagine a scenario involving a couple named Christopher and Natalie in Miami, Florida. They have been litigating for 18 months, and they finally arrive at their first temporary orders hearing. In the eyes of the law, this 30-minute window is the most critical inflection point of their entire case. Under the 661 doctrine, the status quo is the most powerful force in the courtroom. If Natalie has been living in the family home with the children for the last 6 months while Christopher lived in a nearby apartment, the judge is highly likely to issue a temporary order that keeps that arrangement in place. This is known as the stability principle. The judge's logic is simple. They want to minimize the disruption to the children until a final trial can be held. However, in the 2026 legal climate, these temporary orders often become permanent realities. If the final trial is delayed by 12 or 18 months due to a crowded court docket, the status quo has essentially become the new law of the land. Christopher may find himself fighting an uphill battle to prove that a 50-50 split is better than the 80-20 split the judge created in a mere half-hour session. Step by step, the discourse examines how judicial bias, often unconscious, impacts the outcome of 661 cases. While judges are trained to be impartial, historical trends show that personal philosophies on parenting and work-life balance often bleed into their rulings. Imagine if Christopher and Natalie appear before Judge Miller, who spent 30 years as a traditional corporate attorney before joining the bench. Judge Miller may harbor a personal belief that a child needs a primary home base, and that frequent switching between houses is detrimental. Conversely, if they appear before Judge Garcia, who is a staunch advocate for fatherhood initiatives, the potential outcomes shift toward a mandatory 50-50 split from day one, regardless of the historical caregiving roles. This is the judicial lottery, and in 2026, it is one of the most unpredictable variables in the U.S. legal system. The 661 analysis also highlights the power of the ex parte order. This is a legal move where one party approaches the judge without the other party being present, usually citing an emergency. Imagine if Natalie files an affidavit claiming that Christopher is planning to take the children out of the state without her consent. If the judge signs an emergency order, Christopher might find his parenting time suspended and his bank accounts frozen before he even knows a motion was filed. The academic discourse focuses on the due process concerns here. While these orders are designed to prevent immediate harm, case studies in 2026 reveal that they are frequently used as strategic weapons to seize the upper hand in the early stages of a 661 dispute. Once an ex parte order is signed, the burden of proof shifts to the accused party to undo the damage, which can take weeks of expensive litigation. We must also analyze the role of the statement of decision. In many jurisdictions after a trial, a judge must provide a written explanation of how they applied the 661 factors to the facts of the case. However, the academic data suggests that these statements are often boilerplate, using standard legal phrasing that makes them nearly impossible to overturn on appeal. To win an appeal in the United States, you generally cannot just argue that the judge was wrong. You must prove that the judge committed an abuse of discretion or a legal error. Since 661 grants judges such wide latitude, the vast majority of family law rulings are upheld. This creates a high-stakes environment where your trial judge is effectively the supreme authority over your life. Now, consider the concept of judicial temperament. In the high-pressure environment of 2026 family courts, judges often handle 20 to 30 cases in a single morning. This leads to a phenomenon called decision fatigue. Academic research shows that the potential outcomes for a litigant can actually change based on whether their case is heard at 9 a.m. or 4:30 p.m. A judge who is tired and frustrated may be less patient with complex financial arguments or nuanced custody concerns. For Christopher, this means his legal team must be able to distill 18 years of marriage into a 5-minute opening statement that captures the judge's attention before their mental energy wanes. The discourse also dives into the rise of the private judge. In 2026, wealthy couples in states like California and Texas are increasingly opting out of the public court system altogether. They hire a retired judge to hear their case in a private office. This is known as a reference to a private judicial officer. The benefits are clear. The parties get a judge who has the time to read every document, and the proceedings remain confidential. However, the academic critique of this system points to a two-tiered justice system. The 661 discourse is being shaped by these private rulings that the public never sees, creating a hidden body of law accessible only to the top 1% of the American population. Furthermore, we must address the impact of judicial intervention in settlement negotiations. Many judges in 2026 take an active role in pushing parties toward a deal. This is often done in a settlement conference, where the judge tells the lawyers exactly how they would rule if the case went to trial. This is a powerful psychological tool. If Judge Miller tells Christopher that he has zero chance of getting more than 40% of the assets, Christopher is likely to settle for 35% just to end the litigation. The 661 framework is thus used as a hammer to force agreements, even when those agreements might not be truly equitable. Imagine if the discourse shifts to the use of technology in the courtroom. In 2026, many family law hearings are still conducted via video conference. This has a profound effect on the judge's ability to assess the credibility of a witness. When Christopher is testifying through a screen, the judge cannot see his body language or look him in the eye in the same way they could in person. Academic studies suggest that this digital barrier can lead to harsher rulings, as the human element of the case is diminished. The 661 discourse must now account for the medium through which the evidence is presented. The final element of the black box is the role of the court reporter. In the 2026 academic discourse, the record is everything. If a judge makes a comment that shows clear bias, but it isn't captured in the transcript, it effectively never happened. High-stakes 661 cases involve legal teams that are obsessively focused on preserving the record for a potential appeal. Every objection and every ruling is a brick in the wall of the legal narrative. What we see in this part of the deep dive is that the law is not a machine. It is a human institution. The 661 rules are the ingredients, but the judge is the chef, and the final dish is often a surprise. But even when the judge signs that final decree, the story is rarely over. Because in the modern American economy, a court order is only as good as the ability to enforce it. As we conclude this look into the courtroom, we have to face the reality of what happens when the signatures are dry. We are moving from the black box of the judiciary into the complex world of post-decree life. In the next part, we are going to explore the world of enforcement and modification. What happens when the money stops flowing or the parenting schedule is ignored? We will dive into the world of contempt of court, the modification of support due to job loss in the 2026 economy, and the rise of parental alienation litigation. The war doesn't end with the divorce. Sometimes, it's just the beginning of a new phase of conflict. In Part 8, we will show you how to protect the order you fought so hard to get. The final signature on a divorce decree is often mistaken for a finish line, but in the academic discourse of the 661 framework, it is merely the transition into the enforcement and modification phase. In 2026, a court order is not a self-executing document. It is a set of instructions that requires constant vigilance. Imagine a scenario involving a character named Michael in Chicago, Illinois. Michael successfully navigated a high-conflict divorce in 2025, securing a specific alimony structure and a 50-50 parenting plan. However, 6 months into 2026, his ex-spouse begins to unilaterally cancel weekend visitations and has missed 3 consecutive spousal support payments. Under the 661 enforcement protocols, Michael cannot simply call the police to resolve a civil parenting dispute. Instead, he must enter the world of contempt of court. This is a formal legal process where one party asks the judge to find that the other party has willfully violated a clear and unequivocal order. Step by step, Michael's legal team must document every missed minute and every unpaid dollar. In the 2026 legal landscape, historical trends show that judges are becoming less patient with incremental violations. If Michael can prove a pattern of behavior, the potential outcomes range from the assessment of the other party's legal fees against them to, in extreme cases, incarceration or a mandatory transfer of the children to Michael's primary care to ensure compliance. We must also analyze the doctrine of modification based on a substantial change in circumstances. The 2026 American economy is characterized by rapid technological shifts and career volatility. Imagine if Michael's company undergoes a massive AI-driven restructuring, and his executive salary is cut by 40%. Under 661 rules, his support obligation does not automatically adjust to his new reality. He must proactively file a motion to modify. If he waits 3 months to file the paperwork, he is legally responsible for the original, higher amount for those 3 months, even if he didn't have the funds. This is known as the rule against retroactive modification. Academic data highlights that thousands of Americans fall into deep debt because they assume the court will understand their job loss without a formal filing. The step-by-step reality is that the court only cares about the date the process server delivered the notice to the other party. This leads us to the high-stakes world of parental alienation litigation, a recurring theme in the 2026 academic discourse. Imagine if the children start refusing to go to Michael's house, repeating specific adult grievances they have overheard. In a 661 context, the court must distinguish between a child's legitimate preference and a parent's intentional campaign to disparage the other. This often requires the appointment of a reunification therapist. Case studies show that these cases are among the most expensive and prolonged in the family law system. The discourse focuses on the potential outcomes of intensive intervention versus a change in custody. In 2026, more judges are leaning toward the use of temporary custody flip orders, where the child lives exclusively with the alienated parent for 90 days to break the cycle of influence. Now, consider the complexities of interstate enforcement. In a mobile society like the United States in 2026, it is common for one parent to move to a different state after the divorce is finalized. This triggers the Uniform Interstate Family Support Act and the Uniform Child Custody Jurisdiction and Enforcement Act. If Michael's ex-spouse moves to Florida and stops paying support, Michael must register his Illinois order in a Florida court to garnish wages or seize assets. The academic discourse emphasizes the friction in these multi-jurisdictional battles. Each state has slightly different administrative procedures, and the cost of maintaining legal counsel in 2 different time zones can quickly deplete the very funds being sought for enforcement. Furthermore, we must examine the role of the State Disbursement Unit in 2026. For child support, most payments are now funneled through state-managed electronic systems. This creates a definitive digital ledger of payments. Historical trends suggest that parents who pay under the table or directly to their ex-spouse often face a nightmare scenario where the state records show they are in arrears because they bypassed the official system. Under 661 logic, if the payment isn't in the state system, it effectively didn't happen, and the payer may be forced to pay twice to clear their record and maintain their driver's license or professional credentials. In the realm of property division enforcement, imagine if the divorce decree ordered the sale of the family home by the spring of 2026. but one party refuses to sign the listing agreement or keeps the house in a state of disrepair to prevent a sale. The 661 framework provides for the appointment of a receiver or a special master. This is a third party empowered by the court to sign the documents on behalf of the recalcitrant spouse. Step by step, the court strips the resisting party of their agency to ensure the final distribution of equity occurs. The academic data indicates that while this is a powerful tool, the fees for a receiver are often deducted from the house proceeds, resulting in a net loss for both parties. The 2026 Discourse also covers the rising trend of life event triggers in modern decrees. Many 661 orders now include automatic escalation clauses for child support tied to inflation or cost of living adjustments. While this is designed to reduce future litigation, it often creates confusion when the specific index used is ambiguous. Case studies reveal that disagreement over which consumer price index to follow can lead right back to a modification hearing. Legal professionals are now moving toward hyper-specific language that cites the exact government database to be used on an annual review date. We also have to discuss the impact of cohabitation on spousal support. In many 2026 settlements, alimony terminates if the recipient enters a marriage-like relationship. However, the academic challenge is defining what constitutes a marriage-like relationship in a gig economy, mobile-first world. If Michael's ex-spouse has a partner who spends 5 nights a week at the house but maintains a separate mailing address, is that cohabitation? The 661 Discourse explores the use of private investigators and digital surveillance to prove a shared life. Potential outcomes depend heavily on the specific state's definition of economic interdependence, whether the new partner is contributing to the grocery bill or the mortgage. Finally, we must look at the psychological toll of the forever litigation cycle. Academic research suggests that for a specific subset of high-conflict personalities, the enforcement and modification phase becomes a way to maintain a connection to their former spouse. In 2026, courts are increasingly using vexatious litigant designations to prevent individuals from filing frivolous motions. If Michael is targeted by dozens of meritless filings, the court can order that his ex-spouse must get judicial permission before filing anything new. As we conclude this part on protecting your order, we have to look at the intersection of family law and the digital afterlife. What happens when the assets aren't just houses and cars, but digital legacies, encrypted data, and the algorithmic value of a person's online existence? The 661 Discourse is moving into the final frontier of the virtual world. In the next part, we are going to explore the division of the digital self. We will look at the ownership of social media accounts, the rights to AI-generated likenesses of the parties, and the battle over data privacy between ex-spouses. The digital ghosts of your marriage are waiting, and in Part 9, we will show you how the cloud is becoming the new battlefield for the American divorce. The academic discourse now moves into the ethereal yet legally concrete world of the digital estate, a domain that has fundamentally redefined the 661 framework in 2026. In the United States today, a marriage is no longer just a physical and emotional union. It is a complex data-sharing agreement. When that agreement dissolves, we are left with the problem of the digital ghost, the persistent, algorithmic remains of a shared life that do not fit into traditional categories of property like a car or a house. Imagine a scenario involving a couple named Alex and Taylor in Seattle, Washington. Both are professionals in the tech sector, and over 12 years of marriage, they have built a sprawling digital ecosystem. They share a cloud storage account with 40,000 photos, a family YouTube channel with a dedicated following, and a suite of smart home devices that have been learning their habits for a decade. Under the 661 lens, the first hurdle is the valuation and division of social media assets. In 2026, a social media account is often a primary source of income or, at the very least, a significant marketing tool. If Taylor has a professional Instagram account with 500,000 followers that was built during the marriage, the court must decide if the account itself is a marital asset. Step by step, the court examines the brand equity and the potential outcomes of future monetization. Case studies from the early 2020s paved the way for this, but in 2026, the complexity has scaled. The court may order a revenue-sharing agreement where Alex receives a percentage of Taylor's brand sponsorships for a set period, acknowledging that the growth of that audience was supported by marital resources and time. However, dividing the account is impossible without destroying its value. You cannot give 250,000 followers to one person and 250,000 to another. The discourse focuses on the transition from property to income stream. requiring forensic digital marketers to testify on the projected lifetime value of the digital handle. This leads to the deeply personal and often traumatic battle over data privacy and digital boundaries. Imagine if Alex and Taylor used a shared password manager. After the split, the risk of digital stalking or unauthorized access to sensitive information is a primary concern. The 661 framework in 2026 now incorporates the digital divorce audit. This is a step-by-step process where legal teams oversee the separation of digital identities. It involves changing every password, deauthorizing shared devices, and untangling joint banking apps. Historical trends show that digital domestic abuse, the use of location tracking or shared account access to monitor an ex-spouse, is a rising factor in contempt of court filings. The court may issue a digital restraining order, which specifically forbids one party from accessing the other's cloud accounts or using smart home technology to interfere with their living environment. Imagine Alex trying to sleep in the family home while Taylor, from a remote apartment, repeatedly turns on the smart lights or adjusts the thermostat to 85 degrees. In 2026, this is not just a nuisance. It is a violation of the 661 status quo. We also have to analyze the ownership of the AI likeness. This is the newest frontier in the academic discourse. Imagine if Alex, a hobbyist programmer, created an AI avatar of the family for their YouTube channel, using their collective voice recordings and photos. Who owns the rights to that digital persona once the marriage is over? Under the 661 doctrine of intellectual property, the court must determine if the AI model is a work made for hire, within the marriage or a separate creative endeavor. If the model was trained on data from both parties, the potential outcomes are legally unprecedented. Does Taylor have a right of publicity that allows her to veto the use of her voice in Alex's future AI-generated content? The 2026 legal landscape is shifting toward a requirement for explicit consent, where the use of a spouse's digital likeness in post-divorce media requires a licensing agreement or a buyout. The discourse then turns to the digital family Bible, the cloud-based archives of the children's lives. In a 661 deep dive, the court must address the right to memories. If Alex manages the primary Google Photos account, he has the power to delete 12 years of Taylor's history with a single click. To prevent this, modern parenting plans in 2026 include a digital preservation clause. This mandates that the parties provide each other with a full unedited export of all shared digital media. Step by step, the legal teams coordinate the transfer of terabytes of data. The cost of this forensic data duplication is now a standard line item in high-net-worth divorce budgets, often costing upwards of $5,000 to ensure no metadata is lost and no privacy is breached. Furthermore, we must examine the intersection of 661 and the smart estate. In 2026, many American homes are equipped with integrated systems that control security, energy, and even grocery replenishment. If the house is awarded to Taylor, the transfer of the digital deed is as important as the physical one. This involves the transfer of administrative rights for every IoT device in the residence. Historical trends suggest that failure to do this leads to digital homelessness, where the spouse remaining in the house cannot even unlock their own front door because the administrative account is still in the name of the spouse who moved out. The academic discourse emphasizes that the legal profession must now act as a tech support liaison, ensuring that the digital transition is as seamless as the physical one. Now, consider the rise of digital legacy planning in divorce. In 2026, many individuals have digital assets like cryptocurrency, non-fungible tokens, NFTs, or even virtual real estate in decentralized platforms. These assets are often protected by private keys or biometric locks. If Alex refuses to provide the seed phrase for a crypto wallet containing marital funds, the court faces a jurisdictional nightmare. Under 661 protocols, the court cannot force a decentralized network to reset a password. Instead, they must use the coercion of the person. This means the judge may hold Alex in jail for civil contempt until he chooses to reveal the key. The academic discourse highlights the friction between the immutable nature of the blockchain and the coercive power of the state. Beyond the finances, there is the sociological impact of the algorithm of divorce. In 2026, your digital footprint determines your social standing and your professional opportunities. If a bitter ex-spouse engages in review bombing of a spouse's business or leaks private, but non-explicit data to damage their reputation, the 661 framework struggles to provide an adequate remedy. We are seeing the rise of the digital reputation escrow, where a portion of the marital assets is held in a trust for a set period. If one party violates a non-disparagement clause online, the funds are forfeited to the other. This creates a financial incentive for digital civility in an era where an angry tweet can destroy a career in minutes. The 661 Discourse reveals that the digital world has made privacy an expensive luxury and data a dangerous weapon. We are no longer just dividing what we can touch, we are dividing the very information that defines us. But as we navigate the cloud and the code, we are approaching the final and most profound question of the entire process. After the lawyers are paid, the house is sold, the kids are scheduled, and the data is divided, what remains? As we move toward the final chapter of this masterclass, we have to look at the post-divorce reconstruction. We are moving from the battlefield of the 661 framework into the psychology of the survivor. In the final part, we are going to explore the data on long-term happiness, the socio-economic reality of the second act, and the definitive checklist for moving forward in 2026. The war is ending, and in part 10 we will show you how to win the peace. The academic discourse on the 661 framework reaches its final, most critical conclusion: the transition from legal dissolution to socio-economic reconstruction. In 2026, winning the peace requires a fundamental shift from an adversarial mindset to a strategic, long-term management of one's new reality. We have spent 9 parts deconstructing the technical, financial, and digital battlegrounds, but the final part of this masterclass is about the human result. Imagine a character named Sarah in Atlanta, Georgia. She has just received her final decree after 2 years of litigation. The house is sold, the QDROs are filed, and the parenting plan is set. For Sarah, and for many in the United States in 2026, the question is no longer about what was lost, but how to optimize the remaining capital, both financial and emotional. Historical trends indicate that the first 24 months post-divorce are the most volatile for a person's net worth. In the academic study of the second act, this is known as the recalibration period. Step by step, Sarah must perform a post-divorce financial audit. This involves more than just opening a new bank account. It requires a total restructuring of her tax identity. In 2026, the potential outcomes of failing to update beneficiaries on non-probate assets, such as life insurance policies, 401ks and transfer on death accounts, can be catastrophic. Case studies from recent years show instances where an ex-spouse inadvertently inherited hundreds of thousands of dollars because the decedent forgot to update a single form at their HR department. Winning the peace starts with the administrative scrub of your past life to ensure your future assets are protected for your chosen heirs. Beyond administration, we must analyze the socio-economic reality of the single-income household in a high-inflation environment. For Sarah, the 661 framework provided a specific alimony and child support amount, but academic data suggests that the purchasing power of these fixed payments often erodes faster than the annual cost of living adjustments can keep up. To counter this, the discourse explores the concept of the individual economic pivot. This involves Sarah leveraging the vocational skills we discussed in Part 3 to maximize her earning capacity. In 2026, the trend for divorced professionals is to pursue specialized certifications or micro-credentials that offer a high return on investment. The goal is to move from a state of reliance on support to a state of self-sufficiency where alimony becomes a secondary, rather than a primary income stream. Now, consider the psychological reconstruction of the family unit. The 661 Discourse highlights that the most successful post-divorce outcomes occur when parents transition into a business partner relationship. Imagine if Sarah and her ex-husband, Mark, treat their co-parenting meetings like a corporate board meeting. They use a shared digital calendar, they stick to a strict agenda regarding the children's expenses, and they keep emotional grievances out of the communication channel. Academic research into child development in 2026 shows that children who see their parents interacting with professional civility, even if there is no underlying friendship, show significantly lower levels of cortisol and higher academic performance than those in high-conflict environments. This is the science of winning the peace. It is the intentional reduction of friction. We must also address the credit rebuilding phase. In many U.S. divorces, the process of untangling joint debt and selling a shared residence can temporarily depress a person's credit score. Step by step, Sarah must re-establish her individual credit profile. This involves the strategic use of credit-building tools and the careful monitoring of her credit report to ensure that Mark's future financial decisions do not impact her score through any remaining joint accounts. The discourse emphasizes that in the 2026 economy, your credit score is your most valuable and tangible asset, determining your ability to secure a new mortgage or even a competitive insurance rate. Furthermore, we must look at the social capital of the second act. Divorce often results in a contraction of a person's social network, as mutual friends sometimes feel forced to take sides. The academic data suggests that the most resilient individuals are those who proactively build new, independent social circles. For Sarah, this might mean joining professional organizations, community groups, or networking events that are unrelated to her previous life. This isn't just about emotional support, it is about building a new ecosystem of opportunities. In the 2026 discourse, this is referred to as the social diversification strategy. As we look at the definitive checklist for moving forward, we must include the digital sanitization process. As we explored in Part 9, the digital ghosts are persistent. Sarah must ensure that her digital legacy is secure. This includes a full review of her privacy settings on every platform, the removal of any shared location tracking features, and the archiving of her digital history in a way that allows her to move forward without being constantly reminded of the litigation. The potential outcomes of a clean digital break are a significant reduction in anxiety and a faster return to professional focus. The 661 discourse concludes with the long-term happiness longitudinal study data. When we look at individuals 5 to 10 years after their divorce in the United States, we see a clear divergence. Those who remain trapped in the enforcement and modification cycle, the war we discussed in Part 8, frequently report lower levels of life satisfaction and higher rates of health issues. Conversely, those who followed the 661 principles of equitable distribution, professional co-parenting, and financial independence often report a growth peak. They describe the divorce not as a failure, but as a necessary, albeit painful structural reorganization that allowed for a more authentic and stable second act. Imagine if Sarah, 5 years from now, looks back at the 661 process not with bitterness, but with the cold clarity of a survivor who has successfully navigated a complex system. She has a new home, her children are thriving in their 50-50 schedule, and her career has reached new heights because she was forced to innovate. This is the ultimate goal of the academic discourse. It is to provide the data and the framework so that the dissolution of a marriage does not become the dissolution of a person's future. This concludes our 10-part deep dive masterclass on the academic discourse of Divorce 661 in the USA. We have traveled from the initial filing and the viral hooks of the legal system, through the forensic audits and the battle for time, into the black box of the courtroom, and finally to the reconstruction of a life. You now possess the academic blueprint for understanding one of the most complex legal and sociological phenomena in modern America. The knowledge you have gained here is your primary tool for navigating the 2026 landscape with precision and perspective. While this masterclass on the 661 framework has come to an end, the evolution of the American legal system never stops. As we look toward the future, new questions are emerging on the horizon. Questions about the impact of decentralized autonomous organizations on marital property, the role of biometric data in custody, and the changing definition of the family unit itself. The discourse continues, and the next great shift in the American social contract is already beginning to take shape. Stay tuned as we prepare to dive into our next investigation into the hidden mechanics of the U.S. economy and the laws that govern our lives.